What is summary judgment? My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. Today we're going to talk about one of the most important parts of any lawsuit, and that is what's called the summary judgment stage. You're usually going to run into it after you've done all your discovery, you've done your depositions, you've exchanged expert reports, and at that time, the court will accept written submissions from you and the opposing party in the form of a motion. And what summary judgment will allow the court to do is decide if there has to be a trial or not. So what summary judgment is it's a decision by the judge after reviewing these motions, and the judge says whether or not an issue or the entire case can be resolved without the need for a trial. The judge will look at the evidence presented by your side, look at the evidence presented by the other side, and determine, based on the issues in front of the judge, whether there needs to be a trial. The most common things that people will look for is what's called an issue of fact. So if all of the facts are agreed to by both parties, then it really is just an issue of law in your case, which is why you will often see a summary judgment application from one or both sides in a breach of contract case, because normally the contract is admitted by both parties. Everyone agrees they signed that contract, and usually you can agree to the facts of what happened surrounding that contract, and so the question becomes an issue of law for the judge to decide. So the judge is looking at the law and applying that to this particular contract, which side should prevail. And if the judge can do that and there's no issues of fact and we're just applying the law, then the judge doesn't need to have a trial, doesn't need to take up all that time, maybe bring in a jury and go through all of the evidence, when they can just apply the law and figure out who should be winning or should be losing that case. So summary judgment's a really important part of your case. It's also important for you to make sure you know whether or not it's available in your case. So there will be certain types of cases out there where summary judgment is not going to be available to you. Or more importantly, summary judgment is just going to be impossible because there's too many issues of fact, meaning that you and the other side just can't agree on what actually happened. And in that case, the judge is probably going to have a trial so that they can hear witnesses on both sides and look at evidence and decide who should be victorious and who should lose, or some other disposition of the issues and some other way to resolve the case. The way we get to summary judgment is we make a motion. So usually either party can make a summary judgment motion. If you're dealing with a lawsuit, it's often the defendant who will make a summary judgment motion saying the plaintiff has not proven their case, and based upon all the facts in the law, here's the reason why, judge, the case should be dismissed. At the same time, plaintiffs can also make a summary judgment motion that says, I've proven my case. Here's the contract. Here's the undisputed facts. Here we are, judge. You should grant in favor of the plaintiff, and you don't need a trial for doing that. When both of you are moving for summary judgment, so you usually have a motion for summary judgment and a cross motion for summary judgment, you're essentially having a mini trial before the judge. Now, unlike an actual trial where you have to set aside a few days and you have to go to the courthouse and sit there at the table and listen to everybody present evidence and the attorneys are questioning and cross-examining and there's objections and maybe there's a jury, a summary judgment motion is usually a mini trial in that there's just oral argument. So one side's attorney will make their arguments, the other side's attorney will make their arguments, and the judge will say, I'm going to take it under advisement, and then they will issue a decision. The evidence that's going to be presented at this mini trial will be things like contracts, other records of payment, other documents you may have. If you've done depositions, you can have deposition transcripts, and you can have expert reports. Now, if you've ever dealt with an expert before, you know that experts are not cheap, and hiring them to show up and testify for a day of trial is very expensive. That's why if you're able to get the case resolved on the summary judgment motion, you could be saving yourself a lot of time and a lot of money with that expert. So unlike that trial, there's not usually going to be live testimony. The expert won't have to come in. You won't have to get on the stand and testify. Instead, the testimony is presented in what we call affidavits or declarations or other sworn statements. So these are going to be written documents presented to the judge with all the facts laid out, and it's signed and usually notarized saying that I swear to the truth of it. So essentially it's written testimony for the judge to consider. So people will always ask then, if we have a summary judgment motion, how does this work? What's the timing look like? Is it a fast process, slow process? So the first thing I'll tell you is it's going to depend on what court you're in. Each court has its own provisions for how it handles summary judgment motion. But the basic way it's going to happen is, number one party is going to file their motion for summary judgment. Second, the other party is going to file their response, usually called an opposition. In some cases, like I discussed before, it'll actually be a cross motion. So now you have two motions for summary judgment. The third step is that the original filer will then get the right to file a reply. So you have a motion, an opposition, and a reply. If there was a cross motion, some courts will allow the party making the cross motion to then actually submit a reply as well. Once we have all the papers submitted, the judge will set it down for a hearing. They'll set a time on their calendar for the attorneys to come in and present their arguments. These can be short hearings, these can be long hearings. It's all going to depend on the judge that you're in front of. And so once you've submitted your documents, once you've made your arguments, then the case is considered submitted to the judge for consideration. And the judge will then take their time and review the documents, review the oral argument. In some cases, the judge will ask you to actually order the transcript so that the judge can have the transcript of the hearing in front of them too, so they can look through all the arguments. Once the judge has gone through all of this, the judge makes a decision. So what the judge's decision says is, I'm granting or denying summary judgment. And the judge can do this on certain issues, saying I find this issue in favor of one party, but I want a trial on the other issues. Or the judge can say, looking at everything here, there's no undisputed facts, the law is clear, then this party actually wins the case, and I'm going to submit an order that says the case is either dismissed or the case is granted in favor of the plaintiff, or maybe granted in favor of the defendant. So this is a real quick interview of summary judgment. There's books and books out there in the legal world that will go through the entire summary judgment process. There are different standards. There's a lot of techniques and there's a lot of other tactics that lawyers will use when it comes to summary judgment. If you're involved in a lawsuit with yourself personally, I'm going to encourage you, do not try to do a summary judgment yourself. Even if you've been representing yourself through discovery, you think you're doing well, summary judgment is an extremely important part of your case. And you wouldn't want to lose the ability to get summary judgment because you had a small mistake, a small pebble. You messed up a little bit of the procedure that the court requires. So what I would do is work with professionals, reach out to an attorney, even if you've been representing yourself, and say, can I at least get some of your time to sit down and talk about summary judgment and whether it makes sense to bring in an attorney to help you with that motion. If you're ready to get started, or if you'd like to discuss the process further, you can go to my website, andrewmayers.com. There's a red legal strategy session button on the front page. You'll be taken to my personal calendar. We'll set up a legal strategy session, which is a 15 or 20-minute phone call, and we can discuss where you are in the process and what are those next steps for you in your litigation. Or if you've never actually been in litigation, but you're afraid one is coming up, and you want to understand the timing and the cadence of a lawsuit, and especially how important summary judgment is, let's have a legal strategy session call. We'll talk these things through so you have a good roadmap for how to handle that lawsuit.